Good afternoon, everybody. Welcome to the first of our Health Law Compliance webinar series. Each year we try to do a compliance webinar series to bring you up to speed on kind of some of the latest developments, as well as an overview of the compliance issues that face healthcare providers. My name is Kim Stanger. I'm the head of Holland & Hart's Health Law Group, and we're pleased to be able to provide these programs for you. This month, we're going to be focusing on federal fraud and abuse laws. Today, I'll be talking about the laws themselves. Next, or in a couple of weeks, I'll be talking about some of the common situations when these arise and what you need to do to apply the laws to those common situations. On March 30th, my partner Jay DeVoy will be talking about what happens, what to do if you happen to be non-compliant. And there's a list of some of the other programs we've got coming up throughout the rest of the year. So with that preliminary, let's get into it. Today, we're going to be talking about the Federal False Claims Act, the Anti-Kickback Statute, the Eliminating Kickbacks in Recovery Statute or Act. Sorry, I've got the wrong name there. It's Eliminating Kickbacks in Recovery Act, or EKRA, the Ethics and Physician Referrals Law, or STARK, Civil Monetary Penalties Law, some healthcare criminal statutes, and I'll give you kind of heads up to some of the common state statutes that are out there. Bit of a disclaimer here. This is going to be a quick overview of the most relevant federal laws and regulations. This is not comprehensive. There's other stuff out there, particularly state laws. So just realize we're going to be focusing on these key federal laws, but it's possible that your state may have other laws out there that apply to you. In addition, the application may depend upon your particular circumstances. For example, most of these federal laws, not all of them, but most of them apply if you are participating in federal healthcare programs. If you're not doing any federal healthcare program business, you may not have to worry about some of these federal laws, but you may have state laws that still apply. Make sure that when it comes time to actually applying this, that you crack the books and actually look at the requirements, particularly the Anti-Kickback Statute and STARK. They have safe harbors, but it's important that you satisfy each of the requirements of those safe harbors. So make sure that you consider the particular facts and circumstances and apply the law. Check with your attorney if you need one. We're recording today's webinar, so we're not going to take questions. But if you do have questions after when we're going through this process, you can go ahead and submit those to me using the chat feature, or you can email me at the email address that's up there on the screen, and I will do my best to respond offline. You should have received a link with to the PowerPoint slides, also some other resources that are available for you. If you didn't get that, you can send an email to Charles per the address in the chat feature, and we'll make sure that we get that to you. All right, let's talk about the False Claims Act. The False Claims Act is kind of the government's main weapon in going after federal fraud and abuse types issues. The False Claims Act goes all the way back to the Civil War. It says you cannot knowingly submit a false or fraudulent claim for payment to the federal government, nor can you knowingly make or use a false record or statement. Now, that was amended more recently to also say, okay, not only can you not submit this false statement, but if you do submit it, even though you didn't know that it was wrong at the time you submitted it, and you become aware that you've been paid improperly, that you've received an overpayment, then you must report and repay that overpayment within the later of 60 days, or the date the cost report is due, if you're paid on a cost report basis. If you fail to do that, then it converts into a false claim. Okay? So it may not have been knowingly false. You may not have known that it was false when you submitted it, but if you subsequently realize that it was false, or that you didn't satisfy the particular requirements applicable such that you have received an overpayment, meaning that you received money to which you are not entitled under applicable regulations or laws, then you've got that affirmative obligation to narc on yourself and repay that within the 60 days, or else it turns into a False Claims Act matter. Well, what's that mean? Well, the penalties associated with False Claims Act, you have to repay plus you have to pay interest. In addition, you can get hit up with civil monetary penalties of $11,000 to $23,000 per claim. Now, that's adjusted on an annual basis. I don't think they've adjusted it for 2023 yet. I think those are the 2022 numbers, but I haven't checked in the last couple of weeks. Now note that that's a civil monetary penalty of that, $11,000 or $23,000 per claim. It's not per mistake that you've made, it's per claim you've submitted. So for example, if you've got a history of using the wrong billing code for a particular procedure and you've done that for 1,000 times, that's not one mistake. That's not one $11,000 penalty. That's 11,000 times the 1,000 times that you submitted that. That's the potential penalty associated with it. In addition, you can get hit up with an administrative penalty of about $22,000 per claim that were, if you fail to return the money to the government that they owe. You can also get hit up with treble damages, and you can be excluded from Medicare or Medicaid. Now you may be wondering, well, how is the government ever going to catch you? Importantly, the False Claims Act also authorizes qui tam lawsuits. Those qui tam lawsuits are claims that are brought by third parties. We'll talk about that more in just a minute. These qui tam lawsuits are a major basis for the government identifying and coming after people. The government, needless to say, is actively involved in seeking to recoup monies that were improperly paid. According to the recent DOJ press release, they recovered more than $2 billion in false claims for fiscal year 2022, which is the second highest number in history, but it's down a little bit from where it was before. Now, as I mentioned, False Claims Act allows qui tam lawsuits. Qui tam lawsuits are lawsuits that the statute authorizes private entities, could be former employees, disgruntled employees, patients, other healthcare providers, competitors, etc. They may sue you under the False Claims Act on behalf of the government. So they act kind of like bounty hunters that are out there. So they can bring these lawsuits on behalf of the government. Once they file that suit, the government has time to decide whether or not they want to intervene and participate in the suit. And then if the suit goes forward, the qui tam relator, if they win, they receive a percentage of any recovery. That percentage is anywhere to 15% to 30% of the recovery that comes out of that, plus they can recover their costs and attorney's fee. So it creates an incentive for these people to report you, to pursue these qui tam actions on behalf of the government. And that's where you see a lot of the big ticket settlements coming out. A lot of those were initiated by these qui tam lawsuits. You may not be concerned that the government's going to catch you, but you have to be concerned about your employees or others. Now, most of you, hopefully, would never dream of engaging in false claims or intentionally false claims or submitting false claims, but they can arise in situations you may not normally think of as false claims. So it may have been a situation where the claims for services were not provided or different than claimed, either through mistake or otherwise. It can also be a situation where you provided the services, billed for it, but you failed to comply with the standards of care, the applicable standard of care. When you submit that claim, you're expressly or impliedly certifying the quality of the care that you rendered. The government generally doesn't pay for worthless care. So if your quality of care did not measure up, then you could be potentially submitting a false claim. Where it usually arises are situations where you fail to comply with the conditions of payment or relevant fraud and abuse laws that pertain to that payment. So maybe you failed to comply with a particular billing requirements, or you failed to comply, you submitted claims that were prohibited under Stark or the anti-kickback statute. The government's taken the position that when you submit that claim to the government, you are expressly or impliedly certifying that that claim complies with the applicable laws and the regulations. For example, you submit that in the cost report of the claims forms. And if you did not comply with those, then it could be a false claim. All right, so that is the weapon that the government uses to come after you most often, and that provides requires that you affirmatively report and repay overpayments that you've received. Let's talk about the next one, the anti-kickback statute. The anti-kickback statute, as its name suggests, states that you cannot knowingly and willfully offer, pay, solicit, or receive remuneration to induce referrals for items or services covered by government programs, federal government healthcare programs, unless the transaction is structured to fit within a regulatory safe harbor. So let's unpack that just a little bit. Note that it says that you cannot knowingly offer and willfully offer, pay, solicit, or receive remuneration. So it's an intent-based statute. You got to have improper intent. It used to be that the courts interpreted that to mean that you had to know that the action was illegal. That is not the case now. Now, it's not a question of whether or not you know that the act was illegal. Ignorance of the law is no excuse. Instead, it just means that you intentionally made that payment, whether or not you knew that it was illegal. Now, note that it not only applies to paying this remuneration to induce referrals, but it also applies to even offering to pay or soliciting or receiving remuneration. So if you have somebody who comes to you and solicits improper remuneration in exchange for making those referrals to them, then that is a violation of the anti-kickback statute. Now, note that it applies unless you can structure the deal to fit within a regulatory safe harbor. The anti-kickback statute has exceptions in these regulatory safe harbors, as their name suggests, that if you structure the deal to fit within those safe harbors, you're safe, right? Because it's an intent-based statute, you are not required to fit within the safe harbor. It's just if you don't, then you're not necessarily safe. Whether or not you actually violated would depend upon whether or not you knowingly and willfully offered to pay, solicit, or the other things there. Now, if you don't fit within the regulatory safe harbor, the courts apply what's called the one purpose test. So if you cannot fit within the safe harbor, the test is whether one purpose of the remuneration is to induce or reward referrals. As you can appreciate, that is a difficult standard to overcome. If you were the defendant, it's somewhat difficult for you to say, no, I know that they were sending me a whole bunch of business. I know I gave them some money, but the fact that they were sending me referrals had nothing to do with the fact that I was giving them money. Note that it is whether one purpose, even if it's a minor purpose, even if you have 99 other legitimate reasons for doing it, if one purpose was to induce or reward these referrals, then that's a violation of the anti-kickback statute unless it was structured to fit within regulatory safe harbor. Well, what are the penalties for an anti-kickback statute violation? This is a felony, folks. You go to jail for this one. Up to 10 years in prison. In addition, a $100,000 criminal fine in the wake of the Affordable Care Act. It also, they can impose civil penalties of $112,000 per violation. You can get hit up with treble damages, and it's automatic exclusion from Medicare or Medicaid. So you're not going to be able to participate in Medicare or Medicaid businesses, probably not going to be able to be hired by the healthcare entity for the reasons we'll talk about a little bit later. In the OIG, the Office of Inspector General's recent updated self-disclosure protocol, they said that the minimum amount that they would settle for an anti-kickback violation is $100,000. Now, in the wake of the Affordable Care Act, a violation of the anti-kickback statute is also an automatic False Claims Act violation. That means that in addition to these criminal penalties, you can also get hit up with the civil penalties that we just talked about under the False Claims Act, including you could be subject to a qui tam lawsuit. Couple of important points about the anti-kickback statute. Note that it only applies to remunerations for items or services payable by federal healthcare programs like Medicare, Medicaid, CHIP, other things like that. If you are not participating, don't receive any or provide any of these services that are payable by Medicare or Medicaid, you generally don't have to worry about the federal anti-kickback statute. You may have a state statute, but you don't have to worry about the federal anti-kickback statute. But you've got to be aware of carve-out programs. Some people are, they're pretty tricky out there. They'll say, okay, I know I can't pay inducements for federal program business, but I'm going to pay this referral source inducements for their private pay business. Now, they may send me their Medicare business too, but I'm not going to pay them this referral for that. I'm just going to pay them for the private pay business. Well, the government said, hey, be careful about doing that because that may actually violate the anti-kickback statute, because we know that if you're paying inducements for this private pay business, that they're likely to also send you their government pay business. And therefore, that amount that you're paying is really to induce referrals for government business also, and therefore it would be a violation of the anti-kickback statute. So they issued an advisory opinion in which they cautioned that those carve-out programs may not be necessarily protected. Now, the anti-kickback statute applies to any remuneration that you offer to induce or reward those referrals. And remuneration is extremely broad. It's basically anything of value. It certainly is money, but it's not limited to money. It could be free or discounted items or services that you provide, perks, gifts, courtesies, professional courtesies, offering free or discounted space, free or discounted use of equipment, meals, insurance, anything of value that potentially implicates this. It could be overpayments or underpayments. Maybe you enter into a contract, but you overpay in order to get the referrals. The government would say that overpayment is to an inducement in order to get those referrals. It could be payments for items or services that are not necessary. You really don't need this service, but this is a good referral source, so I'm going to enter into a contract to have them provide these services as a way so I can get them some money and they'll make referrals to me. But if those items or services are not necessary, then that could be an anti-kickback violation. It could be professional courtesies that you offer to other referring providers. Maybe you don't charge them or their staff for services that they render at your facility. Could be waivers of co-pays or deductibles to the patient, because if you're waiving those co-pays or deductibles, then and they're a federal program beneficiary, you're doing that in order to get their continued business. That would be a violation. Could be low interest loans or subsidies. It could be business opportunities, especially when those are not commercially reasonable. So giving somebody an opportunity, a referral source, an opportunity to invest in your business opportunity could create an anti-kickback situation. Basically, anything else of value. Anytime you are giving or receiving anything to induce or reward referrals for federal healthcare program business, or doing any kind of a deal with a referral source for federal healthcare programs, the bells ought to be going off and you ought to be concerned about the anti-kickback statute. It may or may not be a violation, but you better darn well check to make sure that it's structured appropriately. Case in point, one of the classic cases for the anti-kickback statute was U.S. v. Anderson back in 2001. This is a situation where a clinic paid two physicians who were substantial referral sources $75,000 per year to serve as co-directors and consultants for the geriatric department. So they were getting $75,000 a year, but what did these physicians do in order to earn that $75,000? Well, the court said pretty much nothing. They were just getting that paid, and because they could not show that they were really fair market value services or any real need for their services, the court and or the jury concluded that they were that payment was really intended to induce referrals. That means it's an anti-kickback statute violation. What was the result? Well, one of the physicians got 6 years in prison plus a $75,000 fine and had to pay $142,000 in restitution. Another physician had to go away for 3 years. The clinic's CEO had to go away for 4 years. The CFO, they were originally acquitted, but that acquittal was reversed. The only good news was the clinic attorney was acquitted. But even then, I actually heard this guy speak. I mean, it is traumatic. It is terrible to even have these criminal charges brought against you. And you guys never want to go there, so make sure you're complying with the anti-kickback statute. So this summarizes how that works. If you're offering any kind of remuneration if one purpose is to induce the referrals for items or services payable by federal healthcare programs, it's an anti-kickback violation unless you structure the deal to fit within an appropriate regulatory safe harbor, or you go to the OIG and obtain a favorable advisory opinion. Now, there's a whole bunch of safe harbors, regulatory safe harbors set out of 42 CFR 1001.952, that if you structure your deal to fit within the specific requirements for a safe harbor, then you're going to be safe. But remember, each one of those safe harbors has specific requirements associated with it. You got to satisfy all the requirements in that safe harbor to be safe. For example, there are safe harbors that apply to bona fide employment relationships. There's safe harbors that apply to independent contractor relationships. There's safe harbors that apply to space and equipment rentals, for investments in certain types of entities, or in your own group practice, or investments in ASCs. There's a safe harbor for the sale of a practice, for payments to recruit a practitioner to your area, for certain OB malpractice insurance subsidies. But in order to fit within those safe harbors, you got to satisfy the criteria that are applicable to each one of those. Each one of those has certain conditions. For example, the space personal services or management contracts, if you want to pay somebody as a contractor to provide services, and they're a referral source, in general, the compensation has to be fair market value. It has to be set in advance, and it can't be based on the volume or value of referrals. That's just one of the requirements in that safe harbor. There are safe harbors applicable to the waiver of beneficiary copays for free transportation programs, electronic prescribing items or services, electronic healthcare programs. If, for example, a hospital wants to donate or provide electronic health record systems to other practices in the area, and on and on and on. There's a whole bunch of different safe harbors, but the safe harbors themselves show the scope of the anti-kickback statute, right? If there's a transaction and there's a safe harbor applicable, that means that that transaction is covered by the anti-kickback statute unless you can fit within one of those regulatory safe harbors. The key there is the anti-kickback statute is extremely broad, and you got to be concerned about it if there's any kind of remuneration, financial or otherwise, going back and forth between potential referral sources for federal program business. So the first way that you can avoid that is to get fit within one of those regulatory safe harbors. Another way that you can avoid it is the statute allows you to go to the OIG and get an advisory opinion in advance. Now, those advisory opinions, that the OIG publishes those advisory opinions are on the website. You can go to look at those. They're not binding on anyone except the parties to that advisory opinion. So if you go get a favorable advisory opinion, you're safe, but it doesn't mean that your neighbor can rely on that opinion. It's only binding on the parties to that opinion. But if you structure your deal to fit within the parameters of an advisory opinion that was approved in the past, chances are you're going to be okay, right? Not absolutely safe, but if they approved it in the past, they'll probably approve it for you too. So those safe harbors or those advisory opinions can provide a really good resource to evaluate what are important considerations and whether or not, if you structure your deal accordingly, you may be okay under the anti-kickback statute, even though you don't fit within a safe harbor. Now, in those safe harbors, the government has identified a number of factors that they typically look at to determine whether or not they would issue a favorable advisory opinion. Now, these are not safe harbors. Just because you satisfy these doesn't mean you're safe, but you're safer, okay? These are some favorable conditions or factors that the government may look at, including if there's just fewer limited referrals for program business, if there's a low risk of adverse impact on federal programs, so the way that this is structured as a practical matter really doesn't adversely affect federal programs, if it's done in a way so it doesn't skew clinical decision-making, it doesn't kind of induce referrals based on money rather than patient care need. Is it fair market value, what you're paying for? Now, fair market value in and of itself is not a safe harbor. You can pay fair market value, but it doesn't necessarily mean you're safe. For example, you could pay fair market value for items or services you don't need. In that situation, then it still could be an anti-kickback violation. Did you give notice to patients of this relationship or that you had a financial interest such that the patient understands that, hey, he may have a conflict of interest there? Do not, is it based on, are you compensating based on the referrals so that the compensation structure is structured in a way that the more referrals you make, the more money you make, then that's certainly a red flag. But if it's not based on referrals, that would be a favorable factor. Do you track referrals? If you don't track the referrals, then that helps show that maybe it's not based on referrals and not done with an intent to induce referrals. And there's others. These are just some sample factors that are out there. None of these are dispositive. None of these mean you're absolutely going to be safe. But if you're evaluating the risk of your transaction, these are some of the things that you may want to consider, as well as looking for an advisory opinion that fits your particular circumstance. All right, that is the anti-kickback statute. The anti-kickback statute's younger and more evil twin is the Eliminating Kickback in Recovery Act, or EKRA. EKRA is kind of like the anti-kickback statute on steroids. It came out in the wake of the opioid epidemic. And like the anti-kickback statute, it's a federal statute, says you cannot solicit, receive, pay, or offer any remuneration in return for referring a patient to a laboratory, recovery home or clinical treatment facility unless the arrangement fits within a regulatory safe harbor. So it's very similar to the anti-kickback statute with a couple of important differences. First, remember the anti-kickback statute applies to any item or services that's payable by federal healthcare programs. In contrast, EKRA only applies to referrals for laboratory services, recovery homes, or clinical treatment facilities. So it's narrow in that scope. Second, EKRA is broader than the anti-kickback statute in that, remember, the anti-kickback statute only applies to referrals for items or services payable by federal healthcare programs. EKRA applies to private or public healthcare programs. So it would apply even in the case of private insurance companies or the like. The penalties under EKRA, again, it's a felony, $200,000 criminal fine plus up to 10 years in prison. Now, EKRA only applies to labs, clinical treatment facilities, and recovery homes. But when it comes to labs, labs is not limited to just opioid labs or labs associated with an opioid treatment program. Laboratory is defined extremely broadly to basically include any CLIA lab. So if you're operating a CLIA lab in your physician practice or in your hospital or other facility, doesn't matter if you don't provide substance use disorder programs. If you're operating in a lab, then EKRA potentially applies to you, which means that in addition to the anti-kickback statute, you also have to be concerned about EKRA. And remember that EKRA applies to private payer programs as well as public payer programs. So anytime you operate a lab, clinical treatment facility, or recovery home, beware any inducements to reward or generate business for the lab. Now, like the anti-kickback statute, EKRA has certain statutory safe harbors, but these safe harbors are not the same as the anti-kickback safe harbors, okay? Unlike the anti-kickback statute, which we've got, a ton of regulatory safe harbors, we do not have any regulatory safe harbors for the EKRA. We just have a few exceptions that are listed in the statute itself. And those requirements in that statute do not necessarily track the requirements of the anti-kickback statute. Case in point, under the federal anti-kickback statute, there's a broad exception that applies to bona fide employment relationships, right? Just have to be a bona fide employee. Under EKRA, it's got an exception for bona fide employees, but unlike the anti-kickback statute, under EKRA, you cannot compensate your employees in a way that varies with the volume of value of the business they generate for the lab. So it is narrower than the anti-kickback statute. So beware of that. There's a safe harbor or an exception for discounts under certain health care benefit programs, waivers or discounts of co-pays subject to certain limitations, subsidies to rural health centers, and the like. The bottom line is, if you operate a lab, beware of EKRA. Make sure that if you do anything to incentivize referrals to the lab, that you check the requirements to ensure that you structure that transaction to fit within a regulatory safe harbor. All right, that brings us to the STARK Act, which is really the Ethics in Patient Referrals Act. STARK is similar or related to the anti-kickback statute, but it has important differences. To understand STARK, which is named after Representative Pete Stark, it's helpful to understand kind of the background of it. Back in the late 1980s, early 1990s, the government had changed the reimbursement to physician practices, and they cut back the reimbursement for physician practices. And so physicians were looking for alternative sources of revenue. And back then, Medicare suddenly realized, hey, what's this? We're suddenly seeing a whole lot more claims for labs or, claims for imaging services or these types of things. What's going on? How come we're seeing so many of these? Well, the government looked into it and they concluded the reason that they was all these physicians were going out and investing or starting their own labs and submitting a bunch more claims in order to supplement their income. And Pete Stark and his gang decided, well, we can put a stop to that. So they passed the federal Stark law. Stark says that if a physician or a member of the physician's family has a financial relationship with another entity, that physician may not refer patients to that other entity for certain designated health services, or DHS, that are payable by Medicare or Medicaid. And if the physician did improperly refer, that other entity that receives that referral may not bill Medicare or Medicaid for those designated health services unless you structure the arrangement to fit within a regulatory safe harbor. And if Medicare or Medicaid were improperly billed, then you've got an affirmative obligation to repay the amount that you received improperly within 60 days. If you fail to do so, then you can get hit up with the regulatory penalties. A couple of important points here. Stark does not prohibit financial relationships with referral sources, okay? It doesn't prohibit a physician from having a financial relationship with a hospital or other entity. Stark just says, okay, if you've got that financial relationship, however, you can't make referrals to that other entity unless you structure the deal to fit within a regulatory safe harbor, okay? So Stark doesn't prohibit you as a physician from owning another business or owning another lab or another imaging center. Stark just says, okay, if you're going to own that, that's fine, but you can't make any referrals to that entity unless you structure the deal to fit within a regulatory safe harbor. Now, remember the anti-kickback statute was intent-based. It wasn't necessary for you to fit within a safe harbor. Stark is what we call strict liability. It doesn't matter whether you've got improper intent. Your knowledge makes no difference. If you've got that financial relationship, you can make the referrals. That's just it. And if you do, even though you didn't do it intentionally or you didn't knowingly do it, if you made that referral, then you violated Stark and you're subject to the penalties. What are the penalties? Well, the government does not pay for services that were provided per an improper referral. What does that mean? If you submit a claim that was prohibited from a prohibited referral, then you have not complied with the rules and therefore you have submitted a false claim to the government. You would have an affirmative obligation to report and repay that back to the government. Okay, so no payment for services. In addition, if you submitted the claim improperly, you've got to do a repayment within 60 days. In addition, you can get hit up with civil penalties if you fail to do so, fail to repay it, of approximately $27,000 per claim or $174,000 per scheme to circumvent the requirements under Stark. Again, those are subject to annual adjustments. Those are the 2022 numbers. I don't think they've come out with the 2023 numbers yet, but I haven't looked for a couple of weeks. Now, a violation of the Stark law is almost always going to be a violation of the False Claims Act also, which means that you can also be hit up with those penalties under the False Claims Act, including the criminal penalties, the administrative penalties, or at least the administrative penalties, the civil penalties under the False Claims Act. It's almost always going to be also an anti-kickback statute violation, which means you can get hit up with those criminal penalties. The bottom line is, when it comes to physician relationships, you need to make sure that you satisfy Stark. Let's talk about some of those requirements. Now, remember that the anti-kickback statute applies to anybody. Stark only applies to referrals by physicians, okay? If you don't have this financial relationship, if it doesn't involve any physicians, either directly or indirectly, then you don't need to worry about Stark. Physician or their family members, okay? If it's just with advanced practice professionals or the like, you generally don't have to worry about Stark. But if there are any physicians involved or members of the physician's family, if they're involved in this financial relationship, then you got to worry about Stark. Physicians are MDs, DOs, oral surgeons, dentists, podiatrists, optometrists, and chiropractors. It applies not only to a financial relationship with a physician, but also a financial relationship with a physician's family member, including a spouse, a parent or child, sibling, step-parent, stepchild, step-sibling, grandparent, grandchild, or even in-laws. Okay, so you not only got to be worried about and tracking your financial relationships with your physicians, but also with the physician's family members. Now, like the anti-kickback statute, Stark applies to any kind of financial relationships, which is defined as any remuneration, essentially. So it's not just monetary, but anything of value, any benefit that you're conferring creates that financial relationship. It could be money, like a contract, a lease, joint venture. It could be free or discounted items or services like perks, gifts, professional courtesies to your medical staff members or referring physicians. Could be free or discounted use of space, equipment, meals, insurance trips. Again, anything of value. Could be overpayments or underpayments, payments for items or services that were not provided per the contract. payments for items or services that are not necessary, you really don't need it, professional courtesies, waivers or copays or deductibles, low interest loans or subsidies, business opportunities that are not commercially reasonable, again, anything else of value. Now, it applies to those financial relationships whether they were direct or indirect. Direct financial relationship is when you've got a direct contract or direct financial relationship with that physician or that physician's family member. So you pay the physician directly or the family member directly. It also applies to indirect financial relationships where you don't pay the physician directly, but maybe you pay company A, which is owned by company B, which is owned by the referring physician. So you have to look in this chain of ownership to see if there is a financial relationship, an indirect financial relationship with that referring physician. Again, Stark does not prohibit the financial relationships with the physician. It just says, physician, if you've got a financial relationship with that provider of designated health services, you can't make those referrals to that entity. Now, remember that the anti-kickback statute applies to any referrals for items or services payable by federal health care programs. Stark is more limited. It only applies to referrals for certain designated health services or DHS that are payable in whole or in part by Medicare or Medicaid. DHS includes inpatient and outpatient hospital services, outpatient prescription drugs, clinical labs, physical occupational therapy, speech therapy, home health services, radiology and certain imaging services, radiation therapy and supplies, durable medical equipment and supplies, and certain others. Okay? So, if you've got a financial relationship with a physician, but that physician's not making referrals for any DHS or DHS payable by Medicare or Medicaid, then Stark doesn't apply. You may have an anti-kickback issue if it's payable by Medicare or Medicaid, but you don't have a Stark issue. Stark's only triggered when the physician with a financial relationship is referring these designated health services. And referring does not include services that the physician personally provides. A physician does not refer to himself, so it doesn't include services the physician personally provides. That's why you can pay physicians for services they personally perform, but you may not pay them a compensation formula based on stuff that they order from others, unless you can fit within a regulatory safe harbor. Now, these designated health services, they're defined in the regulations. Check the specific regulations to make sure whether or not you're involved in any of these designated health services. CMS publishes a website that lists some of the affected CPT codes, some of the DHS by CPT codes, like certain radiology services and things like that. But that CMS website is not all-inclusive. So if you go to that website and you look at the CPT code and it's listed there as a DHS, that just means that, yes, that is DHS. But if it's not listed there on that website, doesn't necessarily mean it is not DHS, because the website is not all-inclusive. So when it comes down to Stark, you've got to be concerned if you have any financial relationship, which includes any exchange of an item of value between a physician or the physician's family member and an entity that's going to be providing designated health services. Just a quick example of how the damages in Stark can arise. The Toomey case. This was a situation where the court ultimately concluded that there were certain financial relationships that were structured that violated Stark, that they weren't structured appropriately. Well, because of that, remember, you can't bill the government for claims that were referred in violation of Stark. The government went in and found out that the government had paid about $39 million for services that were improperly billed because they were billed in violation of Stark. So you have to pay that $39 million back. But not only that, remember, under the False Claims Act, they're also subject to treble damages. That's an additional $117 million. Plus, remember, if you've got a Stark violation, you've also got a False Claims Act violation. There were 21,000 claims, 21,000 different procedures or things like that that were referred improperly to this hospital at $5,500 per claim. That was an additional $119 million. The total judgment was $237 million that hospital was responsible for. Now, it ultimately settled for $72 million, the key tam relator, the physician who, or the person who brought this as a key tam lawsuit, they recovered $18 million from that. So that just shows how those Stark penalties can add up quickly and why it's so important that you comply with Stark. So in order to determine whether or not you're complying with Stark, the question is, do you have a financial arrangement with a physician or a member of the physician's family? If so, is that physician going to be making referrals for designated health services? Well, if you've got that financial relationship, they can't make referrals for designated health services. If they do, it's a Stark violation unless you structure the deal to fit within a regulatory safe harbor or you get a favorable advisory opinion from CMS. Let's talk about some of those safe harbors. Stark has 3 classes of safe harbors. Some of those safe harbors apply to both ownership and compensation arrangements. Some apply to just ownership arrangements, and some apply to just compensation arrangements. The Stark safe harbors for ownership and compensation arrangements would include physician services and in-office ancillary services exceptions. These are the important ones. These are the ones that allow a member of a physician group to make referrals to others within their group, okay, without violating Stark. But there's certain things that have to be done in order to do that. Remember, that physician is making a referral to a provider of designated health services. If that group is billing for designated health services, including labs, therapy, PT, or those types of things, that physician's making a referral, even though it's within the group, they're making a referral for designated health services. So you would need to make sure that the transaction is structured to fit within a regulatory safe harbor. This physician services and in-office ancillary services, that's the most important for these intra-group referrals. But in order to get the benefit of those, that group must qualify as a group practice under Stark, which has a bunch more requirements. I'll come back to that in just a minute. Some of the other safe harbors that apply to ownership and compensation, certain payments and prepaid health plans, and so forth. Remember that when it comes to these safe harbors, in order to be safe, in order to fit within Stark, you've got to satisfy all of the regulatory safe harbors. You've got to satisfy all the requirements for a particular safe harbor. You only need to fit within one safe harbor. Each financial relationship need only fit within one safe harbor. But to fit within that safe harbor, you got to satisfy all the particular conditions of that safe harbor. So you need to crack the regulations, look at those requirements, and make sure that you fit within that safe harbor. So those are the safe harbors for ownership plus compensation arrangements. There's a separate bunch of them that apply to ownership only situations where, for example, a physician is investing in another entity. That could be public traded securities, mutual funds. The most important of this is a rural provider. This is the one that allows a rural physician to own and establish a separate imaging center or a separate PT clinic or something like that, as long as they provide those services in a rural area. Then Stark says, okay, you can go ahead and do that. But if you were to do that in a metro area, then Stark would generally prohibit referrals to that entity in which they own. All right, the one you deal with most often are the group of safe harbors that apply to compensation arrangements. These are situations where the physician doesn't have an ownership interest in an entity, but instead there's a compensation arrangement. It applies to their safe harbors for employment contracts, for personal services contracts. There's a new one that applies to remuneration to a physician as long as you pay them less than $5,000 per year. It's kind of a catch-all. That's a good one that they just passed in 2021. That may help you avoid Stark violations. There's one that applies to fair market value, space and equipment leases or timeshare arrangements. If you've got any space or equipment leases or timeshare arrangements with referring physicians, you want to make sure that those are structured to fit within these regulatory safe harbors. There are safe harbors for recruitment and retention payments, non-monetary compensation to medical staff members up to $429 per year. I think that's the current amount. That changes based on cost of living. Medical staff incidental benefits, professional courtesies, and so forth and so on. The key there is that there's a whole bunch of these safe harbors, okay? But in order to fit within those safe harbors, you got to make sure that you satisfy all the requirements for that safe harbor. Remember the anti-kickback statute? It's intent-based, so you've got a little bit of leeway. just because you don't fit within a safe harbor doesn't mean you necessarily violated the anti-kickback safe harbor. Remember, it's the intent, the one purpose test. That doesn't apply to Stark. If you've got a financial relationship with a physician, that physician can't make referrals for designated health services to you unless you structure the deal to fit within a regulatory safe harbor. And in order to do that, you got to fit within all of the requirements of that safe harbor, not just some of them. You got to meet within all of them, or you get an advisory opinion. If you don't fit within the requirements for that safe harbor, unless you get an advisory opinion, then you've got an affirmative obligation to report and repay to the government. If you fail to do that within that 60-day window, guess what? That can turn into a False Claims Act, and you can get hit up with all those other penalties. Now, as I mentioned, there are special rules that apply to group practices that a lot of group practices don't understand. In order to allow physicians within the group practice to refer to others within the group, or refer to the group so the group can bill for services that were not personally performed by that referring physician, generally that group has to qualify as a group practice. In order to be a group practice, you got to satisfy a bunch of criteria. Basically, it's that you truly are operating as a single physician group, not just a bunch of separate physicians who call themselves a group, but don't really operate as a group. So it's got to be a single legal entity. There has to be 2+ physicians. At least 75% of the services provided by physicians who are members of the group have to be provided through that group. It has to be operated as a unified business. There has to be a method of distribution of expenses and income that's determined in advance, so not retroactively. And the big one is that compensation cannot be based directly on the volume or value of referrals, with certain exceptions. There are processes, an exception for paying your physicians personal productivity or giving them a share of overall profits. But if you're going to pay them a share of overall profits, that profit center has to have at least 5 physicians within that profit center. So you can't generally have an eat what you kill structure with less than 5 physicians in that group, or at least that subgroup, unless there's only 3 physicians in the group per se. So beware your eat what you kill models, because those eat what you kill models, if it's basically you get the benefit, you as a physician get the benefit of all the services you perform, plus all the money that you generate, the tests that you order, the DHS that you order, that are, even if they're provided by others, well, that may not comply with Stark. All right, Stark has a very helpful website, a CMS website. You can go here. There's a list of frequently asked questions, a list of those CPT codes that provide some of your designated health services. It has a link to advisory opinions. Remember, like the OIG, you can go to CMS and get an advisory opinion under Stark. They publish those advisory opinions that can provide future guidance to others. There's also the self-referral disclosure protocol. Jay will be talking about that in a couple of weeks, but if you have a Stark violation, there's a protocol that you can go through to narc on yourself, and the government is fairly lenient, or at least they have been fairly lenient in allowing repayments under Stark. So for the Stark analysis, here's the question. Is there a financial relationship with a physician or a family member? That can, remember, be either direct or indirect. It could be an ownership, investment, compensation, or any other payment or benefit. If there is, then you got to ask, does the physician refer DHS payable by federal healthcare programs? If they do, Stark's triggered, okay? If there's a financial relationship, that physician can't make referrals unless you structure the arrangement to fit within a regulatory safe harbor. So number 3, assuming you've got that financial relationship and the physician is or wants to make referrals for DHS, does that arrangement fit within the regulatory safe harbor? If it doesn't, have you obtained a favorable advisory opinion? If not, then guess what? You've probably got a repayment situation going on, or you shouldn't do that arrangement. All right, that is Stark. Let's talk about the Civil Monetary Penalties Law. The Civil Monetary Penalties Law is a bunch of different prohibitions that exist out there that you can run afoul of, right? Including violations of the anti-kickback statute or Stark, or violating EMTALA. It allows for civil monetary penalties to put in place there. The 3 that I wanted to talk about today are offering inducements to program beneficiaries, offering inducements to physicians to limit services, and submitting claims for services that are ordered by or contracting with an excluded entity. First is offering inducements to program beneficiaries. The government's concerned about providers that are out there giving incentives to program beneficiaries, Medicare or Medicaid beneficiaries, in order to get them to come there, because the government thinks that that may promote overutilization and the patients may show up and get services they don't really need. So it generally prohibits offering remuneration to a Medicare or Medicaid beneficiary if you know or should know that it's likely to induce such beneficiary to order or receive services from a particular provider or supplier. So what are the penalties? Well, up to about $23,000 per violation. You can also be excluded from Medicare or Medicaid. And if you're doing that, there's a good chance you've also got an anti-kickback violation. Remember, anti-kickback violations is offered anything to anybody in order to generate referrals, and physicians or patients can refer themselves. So it could also be an anti-kickback violation. Now, under the civil monetary penalties law, remuneration is defined as, like under anti-kickback statute, as anything of value, including but not limited to items or services for free or less than fair market value unless you satisfy certain conditions. And it expressly states waiver of copays and deductibles unless you satisfy certain conditions. So if you've got a practice out there of doing insurance-only billing or not charging Medicare or Medicaid beneficiaries their copay, guess what? That is providing remuneration in violation of the civil monetary penalties law, unless you can fit within a regulatory exception. And the government does, the CNPL does have a bunch of exceptions. These show up in the form as exceptions to the definition of remuneration. For example, remuneration, prohibited remuneration under the civil monetary penalties law does not include waivers or copays based on financial need or after failed collection efforts if certain conditions are met. It doesn't include items or services for incentives to promote certain kinds of preventative care, payments meeting an anti-kickback safe harbor. So if you fit within an anti-kickback safe harbor, you're okay under the civil monetary penalties law, but the reverse is not true. Just because you satisfy one of these exceptions under the civil monetary penalties law doesn't mean you're protected under the anti-kickback statute. There's other types of exceptions here. The key here is to make sure that if you are offering any kind of benefits, any kind of perks, any kind of inducements to your Medicare or Medicaid patients, make sure that you look at these regulations and that you are complying with or fit with outside the definition of remuneration. All right, the next one I wanted to talk about is the hospital or critical access hospital cannot knowingly make a payment directly or indirectly to a physician to induce or reduce medically necessary services. This came out, when we went to the DRG system where hospitals are paid on not based on the actual services that are rendered, but instead the DRG associated with a particular code. Well, that created an incentive for physicians to try, or hospitals to try to reduce their costs. And the government was concerned that the hospital would go to the physicians and say, hey, if you cut back on your costs, we'll give you, certain benefits or certain inducements, or we'll share profits with you, right? The government was concerned by doing that, it would undermine patient care. And so therefore they came up with this prohibition. What are the penalties? Well, $5,600 per violation and possible exclusion from Medicare or Medicaid. It really applies in the situation of gain sharing arrangements, right? Those are situations where, you help us cut costs and we'll share the gains with you. Now, for those of you who are astute enough to recognize this, that sounds an awful lot like accountable care organizations and value-based purchasing in that, right? And the answer is you're right, it does. The question, therefore, is whether or not you've structured that ACO in order to fit within certain regulatory safe harbors. If you do, then you're okay and you don't have to worry about this civil monetary penalties law prohibition. All right, the next one I wanted to talk about briefly was the federal exclusion law. The civil monetary penalties law says that a person who's been excluded from participating in Medicare or Medicaid, so they've had an administrative action brought against them and they've been kicked out of participating in Medicare or Medicaid, that person cannot order or prescribe any items or services payable by federal healthcare programs. So they can't order it. And also, if they happen to work for another entity, that entity cannot submit a claim for an item or services that were ordered or furnished by an excluded person. Not only that, but if you're an owner and you've been excluded, you cannot retain an ownership interest in an entity that participates in Medicare. And if you're an entity that participates in Medicare, you cannot hire or contract with an excluded entity to provide items payable by federal healthcare programs. You can't even contract with an excluded employee. There's a limited exception that if somehow you're able to prove that any compensation you pay that employee, no federal money was used to in determining that person's or coming up with or paying makes its way into that employee's pocket, then you may be able to avoid that prohibition. But that's really hard to do. You're not going to set up separate books or anything like that. So that's really hard to do. The bottom line is if you are excluded in participating in Medicare or Medicaid, it is kind of the death knell for today's healthcare environment if you're going to want to go to work for or with any entity participating in Medicare or Medicaid. Well, what are the penalties? Well, anywhere for $22,000 penalty per item or service that was improperly ordered, treble damages, repayment of amounts paid, and possible exclusion from Medicare or Medicaid. If you happen to hire or contract with an excluded entity, then the government has, at least historically, the OIG has a process that they'll come in there and they'll look and say, okay, well, you paid this guy X dollars, you've received Y dollars from Medicare or Medicaid, we're going to require that you repay us a percentage based on that person's salary, and that they've got kind of a process that they come up with. The bottom line is, if you hire a person who's excluded or contract with a person who's excluded, then you could end up repaying the government tens or hundreds of thousands of dollars based on that contract. So to avoid that, you need to make sure that these people are not excluded. How do you do that? Well, you check that list of excluded individuals and entities on the government's website to make sure that you're not contracting with anything. The government publishes their list of these people who've been excluded, so you're expected to check that. How often do you need to check that? Well, it's not a black and white rule, but they update that on a monthly basis. If you go a few months and that person's on the list, then there's a fair argument that the government could come back there and say, hey, you knew or should have known that this person was excluded. So really, to be safe, you ought to be checking that on a regular basis, every 2 or 3 months. If you look at the Supplemental Hospital Compliance Program guidance, the government said that you certainly ought to check that LEIE before you grant medical staff privileges or before you contract with an entity to provide or employ an entity to provide services. And they said you'd ought to be checking it at least annually for your other employees. Now, they've backed off from that. The Medicaid, CMS Medicaid, said that you'd ought to be checking it monthly. I'm not sure that's necessarily the case, but if you're not doing it every 2 or 3 months, then there's a real chance that if your contractor hires somebody who's excluded, that you're going to have violated that provision. Okay, that is a quick summary of the most relevant federal statutes that I deal with on a daily basis. There are other statutes that are out there. These are kind of the intentionally bad stuff like healthcare fraud, false claims, false statements relating to healthcare matters, bail and wire fraud, or the like, RICO, the Federal Travel Act, which is actually interesting. It's a new theory that allows the government to take like a state law bribery claim, for example, and basically turn it into a federal claim and come against you under a federal statute. So beware of these additional federal statutes. Those are all summarized in the OIG compliance program guidance that are published out there. There are also common state statutes you need to be aware of, including almost all states will have, if not all states, a false claim statute for Medicaid payments that's similar to the federal false claim statute. It prohibits submitting false claims and generally requires repayments in the Medicaid program. So you may not only have to make a Medicaid or a repayment to the federal program, but also to the state program. Almost all states, if not all states, have their own anti-kickback statutes. Quite often, those are limited to government programs like the federal statute, but not all states. Some states have anti-kickback statutes that are broader and also apply to private pay situations, kind of like EKRA. For example, I happen to reside in Idaho. In Idaho, our anti-kickback statute applies to private pay as well as government program business. Some states have self-referral prohibitions or mini Stark laws that either track or are very similar to the Stark law. A lot of states, especially in the Medical Practices Act, will have statutes that prohibit physicians or other licensees from fee splitting, basically paying somebody in order to make a referral. There could be statutes that require notice of financial interest if you were making a referral over to another entity. For example, Utah has a statute that if a physician has an ownership interest in another entity and they're making a referral, that they've got to provide a notice of that financial interest to the patient. There could be prohibitions on offering rebates, discounts, incentives, maybe unfair trade practices laws. The bottom line is know your state law. So don't just worry about the federal law. You've also got to know your state law when it comes to this. Private payers, we haven't touched base with that, but there's an increasing awareness by private payers and going after providers who are failing to comply not only with the contract terms and asserting a breach of contract claim, but maybe using federal statutes like healthcare fraud statutes or state unfair claims practices acts or things like that that may allow them to recover against providers who violate the statutes or contract terms. So in the past, a lot of people don't seem to worry about their financial relationships with payers and maybe being a little bit fast and loose with the rules there or being less than honest, but that is risky also. All right, that's my overview of federal fraud and abuse laws. If you're looking for additional help, the government has a very helpful website that you can go to. They have all sorts of compliance guidance that they publish for different types of provider types. Also, we have a bunch of information, free resources, including free webinars, recorded webinars, publications on our website. You can access that. It's all there for free. And with that said, if you've got any questions, feel free to shoot those to me. Otherwise, we appreciate your participation. In a couple of weeks, I will be picking this up and building on this and talking about how you apply the laws that we talked about today in common situations like employment contracts, contractor agreements, waivers of co-pays and deductibles and things like that. So hopefully you can join us there. Thank you very much, and I hope you have a good week.